So I am very happy to invite our next moderator to come up, Shampa Panda. Shampa is currently a senior associate at Arnold & Porter, but she was like my partner in crime in the Wildlife and Marine Resources section, where she was a trial attorney. We worked on a number of enforcement cases together, but she's also known for her work on the red wolves and other sort of difficult cases and difficult fact patterns where you really need to come up with creative solutions to move the needle. So Shampa, will you come up to the next panel?
Mary, thank you so much for that kind introduction. I'd like to invite our panelists up. I just want to say that I'm really very excited to be, and really very humbled to be moderating this panel with experts in the Endangered Species Act and ways to be creative, to be able to allow the agencies and for the statute to carry out its mission. And we have here experts in the Endangered Species Act for wild and captive species. So I'm looking forward to a fun, robust discussion as soon as Eric gets back to his seat. All right. Just want to start, maybe we can start with Ben. Can each of you please talk about your background and your experience with the Endangered Species Act?
Sure. So I've worked in the solicitor's office at Interior for 29 years. I actually largely retired in June, but I'm still doing a little bit of work here and there. I spent my first 22 years as a staff attorney, mostly working on ESA Section 4 stuff, as well as a variety of MBTA and Eagle Act issues. And then the last 7 years, I was the assistant solicitor for Fish and Wildlife, so I managed about 11 attorneys who provide legal services to the headquarters office of the Fish and Wildlife Service. So in that role, I branched out into Section 7 and a variety of other issues I hadn't had as much exposure to in the previous 22 years. So happy to be here.
Should we just go down the line? Mm-hmm. So I cut my teeth at Meyer Glitzenstein with Eric Glitzenstein. I'm Kathy Meyer, and Kathy really spearheaded use of the Endangered Species Act for captive wildlife. So I was part of a trial team with her litigating the first ever trial involving captive wildlife under the ESA against Ringling Brothers. And from there, I went to the PETA Foundation, where I established and directed the Captive Animal Law Enforcement Division. The very first memo I wrote when I got there was about using the ESA on behalf of grizzly bears who were held in barren concrete pits at a facility in North Carolina. I've gone on to be involved in, I don't know exactly how many, at least 8 citizen suits, challenging takes of captive animals. Obviously, those are all team efforts. I didn't do any of those on my own. I also successfully sued the Fish and Wildlife Service for secretly issuing captive bred wildlife permits, so not going through the required notice and comment process. And I've also published scholarship on captive wildlife under the ESA.
Hi, everyone. So before joining Harvard Law School in January, I was a senior trial attorney in the Wildlife and Marine Resources section of the Environment and Natural Resources Division of DOJ. I came in as an honors grad, did the sort of traditional defense work for the first few years. I worked on a team to defend the polar bear critical habitat designation. listing decisions for ring seal, bearded seals, which were based solely on the impacts to their habitat based on climate change. And my dusky gopher frog case, which I won, I just want to say, try district court level. But over a number of years into my time at DOJ, I started to take notice of some of the cases that were being brought to enforce the ESA, particularly in the captive context, and became pretty frustrated because I am somebody who thinks that, people outside the government are doing really wonderful, great work, but I think that there's a really important role for the federal government to play in enforcement. I think sometimes, for better or worse, some courts are willing to sort of listen to, the Department of Justice's or Fish and Wildlife Services or NOAA's interpretations of, the standards of the statutes, more so than a third party. And I essentially shifted my docket to an all enforcement docket by the time I left. We brought, under the first Trump administration, the first case that I know of the Department of Justice bringing an enforcement Section 9 case and a captive animal case, and that was Jeff Lowe of Tiger King fame, and that was the first of a few cases, but I came here.
Hello, everybody. It's great to be here and get to touch base with so many of these folks around the room who I've dealt with over the years, and just a really inspirational event, even under the difficult times that we are in and are facing. So I started to dabble in the Endangered Species Act at Public Citizen Litigation Group, where Kathy and I first started out. And then we started up our own firm to focus on animal protection, wildlife, natural resource, and other issues. The first really big ESA case we did was the first what's referred to as the multi-species mega listing case, which we actually settled with the outgoing first Bush administration. And that resulted in about 400 listing decisions over the next 4 to 5 years, and gave us sort of an insight into the workings of the agency, and actually worked at that time with some really great Fish and Wildlife Service biologists, and give a shout out to the incredible folks at the service, many of whom have toiled under incredibly difficult circumstances to try to do what they can to protect species. But we wound up bringing lots of ESA litigation, working with great people like Delcy and others, both in the wildlife context, but the animal protection context. And as Delcy said, Kathy masterminded that field with great assistance from some others, but also got a chance to work in that capacity with some of the really excellent NGOs out there, including folks in this room, Defenders of Wildlife, NRDC, and the Center for Biological Diversity, which is where 5 years ago I became the director of litigation at the center, which is a bit like herding cats, but has been a great experience. We've got a couple of great center people here, Catherine and Stephanie, and it's been a really interesting experience. I'll talk more about this probably as we get into the subject matter. As a litigator, I know about both what litigation can accomplish, I think, having done it now for these many years, but what litigation can't accomplish. And it's important to keep interesting answers to the questions, because I think litigation has been critical, but there are limitations to litigation. It can only work effectively in tandem with folks inside the government and academia who are shedding light on important questions. And so I think litigation is a tool we've learned. We've also learned what the limitations of litigation are, and that actually, I think that may be a pretty good segue to some of the topics we're going to talk about on the panel.
Thank you so much. So this panel is going to focus on, as it says, the underutilized authorities in the statute, and we're going to focus on Section 7A1 and Section 9. And so for the first question, moving to Section 7A1 for the law students in the room, That section directs all federal agencies to carry out, quote, programs for the conservation of endangered and threatened species. So as such, it really provides an affirmative and broad mandate to all agencies to take action to conserve species. I'm curious if we could let's start with Eric and then work our way down here. What do you see as the scope of the federal government's mandatory duty to conserve under Section 7A1, and how can it further that mission of the statute? Eric, you've never had to come up with a litigation position for the federal family, so I'd love to start with you.
Wow, if only. So just so we know what we're talking about, I think there was reference to this before, but 7A1 is the less understood, I think, and utilized part of Section 7. 7A2 is the part that says that no agency can jeopardize the continued existence of a species or destroy or adversely modify critical habitat. In order to do that, it has to consult with the Fish and Wildlife Service. So it creates a prohibition, which is sort of more readily understood, I think, in terms of what agencies look at and what they can't do. 7A1, and by the way, Section 7 used to be a unified provision. After TVA versus Hill, it was broken up into these two different sections. But it was all seen, and it's more easy to understand if you think of it. It was all part of one overarching obligation. But 7A1 is stated more in affirmative terms, which is that all agencies shall utilize their authorities to conserve species in consultation with the Fish and Wildlife Service. And this is an important part of 7A1, I think, for people to realize. Like 7A2, it has both a substantive component, but also a procedural component. It tells you what you affirmatively have to do, but it also tells you have to talk to the Fish and Wildlife Service or NIMS about it. And I think that's something to keep in mind as we talk about what 7A1 was meant to accomplish and how perhaps it could be more effectively accomplished going down the road. And as a litigator, it's interesting, I think two of the things we're going to talk about are 7A1 and Section 9, because in terms of ESA citizen suit enforcement, these are actually two areas where, and I think Professor Edelman's charts reflect this, where ESA enforcement through the citizen suit provision is most problematic for non-governmental enforcement. I'll talk more about Section 7 a little bit, but in terms of Section 7A1, as you can sort of understand the concept behind 7A1, but courts have a much more difficult time getting a handle on, well, exactly what does that mean? What does it mean that agencies are supposed to do? Conserve all species? Conserve species that they have some jurisdiction over? It's just much more difficult to get a grasp on exactly what it means in specificity, although we understand the general concept. In terms of what litigation has been able to accomplish, and by the way, if you really want to get a useful understanding of this, a rather remarkable document, and I don't know what the inside parameters of this were, others within the government may have a better idea. This memo that was put out on February of this year, a solicitor's memo, which is called Federal Agency Obligations under Section 7A1 of the ESA, it actually collects pretty much all the case law in a 7-page document, 6 or 7 pages, which is not that difficult because there's not a lot of case law on 7A1, but what it does is capture the sense from the cases that have been decided that 7A1 does impose an obligation. At the same time, by its nature, it affords a great deal of discretion to agencies to determine exactly what a conservation program would look like or should look like, and that it does have some level of specificity in terms of species that the agency has some impact on or some responsibility for dealing with it given its statutory mandate. So the case law in the context of things like the Edwards Aquifer, one of the leading cases, Florida key deer, which was a case involving the flood insurance program, it sort of captures that basic idea, but doesn't flesh out to any great degree exactly what a 7A1 program is supposed to look like. What I will say from the standpoint of private enforcement is that I think the area where private enforcement may be most relevant is where the agency in some way has done something which has not been great for species, but there's really no 7A2 trigger. And I can give you a concrete example of a case I worked on involving the southwestern willow flycatcher. USDA, a number of years ago, was dealing with a situation in which an exotic plant species called salt cedar was destroying riparian habitat where the flycatcher exists. And this is also a story about how humans try to make decisions that they think will be good, and frequently it doesn't turn out that way. they decided the answer to this problem was to bring in an exotic beetle from Asia. I can't remember what the Latin name is, and that was going to actually kill off all the salt cedar and would allow, therefore, the riparian habitats to be destroyed. And when this idea was floated by the Fish and Wildlife Service, the agency quite properly said, well, wait a second, the flycatcher doesn't like the salt cedar as much as the native habitat, but it's learned to exist to some degree in the salt cedar. So if you wipe out all the salt cedar real fast, where's the flycatcher going to go? And they were assured by the USDA that not to worry, the particular beetle that we're going to introduce cannot move down into the latitudes where the flycatcher exists. Well, fast forward a number of years, after the USDA helped promote the release of the beetle throughout this habitat, and it turns out that that's not true. The beetle does go down into those places and wound up, and if you look at the maps, they're really quite startling, because the beetle is a voracious eater of salt cedar. That part of it worked out, but then it was like exponentially increasing the loss of the habitat of the endangered flycatcher. So USDA then basically comes along and says, yeah, I guess we were wrong about that. We're going to make a new decision. We're going to not introduce the beetle into this habitat any longer. We're going to terminate that program. So we're done with that. But at the same time, the beetles that have already been released are like, they didn't say, oh, the program's terminated, so we won't do that anymore. The beetles are still out there eating the salt cedar. So we brought a case, and it's very instructive because I think it highlights 7A1 and 7A2 under both grounds. And we lost the case in the District Court of Nevada on 7A2 grounds where the court said, well, the only affirmative action they've taken recently is to terminate the program. Well, that seems like a good thing, and that's not jeopardizing any species, so you don't have a 7A2 claim. But we actually won that case on 7A1 grounds where the court said, but at the same time, you can't really wash your hands of this whole situation, which is out there, and it's just really bad. And I don't see that you've got any affirmative conservation program, and simply terminating the program that was releasing the beetles is not that. And so basically, it's one of the relatively few cases where there's a fairly concrete ruling where a court looked at it and said, yeah, this seems like the kind of thing where 7A1 imposes some obligation to conserve. And then they basically, kind of hard to come up with a remedy, but we settled the case at that point with an agreement by the agency to, through a NEPA process, identify measures to help mitigate the damage, reaching out to state agencies, telling them you shouldn't do this anymore, and resulted in some concrete, helpful conservation measures for the beetle. So I highlight that one because I think it's an example of where there may be an opportunity for some private litigation, but for the most part, I think it's going to be something where the government really needs to take on more of an active role in this situation. And what would that look like? I think this memo gives you some idea that if the Fish and Wildlife Service was much more to proactively go to agencies and say, this is something that you really need to take seriously. One of the problems is when they write biological opinions, most of it is 7A2, but at the very end of it, there's conservation recommendations, and they say, under 7A1, these are some recommendations we have, but they're completely voluntary. And I think the terminology on that could be changed somewhat, where there's more of an effort made to say, well, you may have some discretion in working these things out, but you do have affirmative 7A1 obligations to actually have meaningful conservation programs. We could talk more about exactly what that will look like. The government folks will have a much better idea than I do. But I think the service, which clearly was going down a very useful role, I think, by putting out this memo, is really the place where we can see some 7A1 utility in the future. And there could be some room for private litigation, but I would say it's one of those areas of the ESA where you can't expect private litigation to basically take the place of the government fleshing out what 7A1 means and how it can be implemented.
So I guess my take on 7A1 is that I think it's tricky on the litigation front because you've got this broad language which, obviously gives the agencies discretion, which is great, flexibility, but it doesn't, when you think about lawsuits, they're in the context of a particular project, a particular, species, particular, action. And the provision doesn't require a conservation program in every instance, right? So you can see where the courts would, many courts may conclude, well, we know they're supposed to do something, but it doesn't mean they have to do this thing. And so therefore, we don't think there's been a violation of 7A1 because they didn't do this specific thing. Like the conservation program doesn't have to be in this specific context. So I'm going to echo what Eric said in that I think 7A1 is primarily an internal provision. I think it's something that is about the role. It's for Fish and Wildlife Service and NIMS to work with the other agencies to the extent that they can, put pressure on them, which I believe somebody, maybe Tim or somebody in the last panel said, hey, that might actually, in order to give them the power to take those steps, that might take an executive order or something from on high to be able to have a little bit more sort of weight behind their words. But one area I see, or from my sort of limited experience where I saw room for improvement is, I think there are a number of agencies who would be willing to take steps to address ESA-related violations or problems. They have no idea what the Endangered Species Act is, what it means, what it does. And the easiest example that I have is U.S. Department of Ag. That is an agency, and particular programs see Endangered Species Act protected animals on a daily basis, all the time. You can go through their inspection reports and you can identify violations of the Endangered Species Act. Like, you can just go through them. They're readily apparent. But I don't think, from my experience, that the folks at Department of Ag have really any deep understanding of the Endangered Species Act. I don't think the inspectors do. And I think there's really room for Fish and Wildlife Service in particular to meet with USDA, to help them get trained up, to help them identify violations and determine how they're going to address them. I mean, it's an issue, but then Fish and Wildlife Service would have to take seriously issues related to captive ESA protected animals. But I'll leave it at that.
Thank you for teeing things up so nicely for me, Mary. So yes, I agree that the U.S. Department of Agriculture, and particularly its animal care subdivision, is an agency that is entirely disregarding 7A1 as well as 7A2. So animal care is tasked with implementing the Animal Welfare Act, which governs more than 2 million animals used for exhibition, experimentation, and the pet trade. And many of those animals, as Mary said, are captive. And we typically think of the Endangered Species Act as a law protecting wild animals and their habitats, and it is that, but it's also been clear from the beginning that it applies to captive members of protected species. And that's because the treatment and what we do with captive members is inextricably intertwined with their wild counterparts. So Fish and Wildlife Service itself has recognized that failure to protect captive members can stimulate commerce and overutilization in species. And so just to give some examples of this intersection, to start with, there's capture for captivity, and that continues to this day. That's exacerbated because there is laundering of animals who are captured from the wild as captive bred. Even when there is true captive breeding, there are very real ramifications for the gene pool of endangered animals. So the gene pool of captive endangered animals is sometimes seen as sort of a safeguard, but if that gene pool is compromised, that's a really big problem. And it is because these animals are very often, more often than not, recklessly bred. And so we see interbreeding between subspecies who would never encounter one another in the wild. That's particularly prevalent with tigers and giraffes, for example. We also just see inbreeding, extensive inbreeding of these animals. And we're just starting to learn about the epigenetic effects of captivity as well. And so those compromised genetics pose threats to the species as a whole. Even just exhibition of captive wildlife can pose problems. So there used to be a belief that exhibiting threatened and endangered animals could somehow help conservation. But despite numerous efforts to try to prove that, there is still no compelling evidence of that. And the U.S. Fish and Wildlife Service has recognized that, and that's why it stopped giving permits out on the basis of education, conservation education. But on the other hand, there is evidence of harm coming from exhibition. This is particularly true in contexts where threatened and endangered animals are displayed in close proximity to human beings. So there's evidence that when people see that, they tend to think that the population is stable, not in need of support, and then to donate less money to conservation. So when we have representations of a species prevalent everywhere and opportunities to get up close to them in person, the public is just lulled into a sense that this species must be doing okay. There's also rampant trafficking of endangered animals, and not just in the world, but in the United States. So you can go online right now and order a lemur from a range of sellers. You can go to an auction and buy a lemur. And the Fish and Wildlife Service, I'm sorry to say, actively facilitates some of this trafficking through its captive bred wildlife permitting scheme. So there are many, many permits issued by the agency that authorize otherwise prohibited activities with captive wildlife. Takes of those animals, buying and selling those animals, transporting them in the course of commerce. And so this is posing really big problems, and this is also exemplified by the fact that we have lots of people who have licenses under the Animal Welfare Act to engage in licensed activities, exhibition, the pet trade, who have ESA convictions. And despite those convictions, they continue to be licensed by the USDA. The USDA takes no enforcement action against them. On the flip side, we see people with captive bred wildlife permits who have dozens of Animal Welfare Act violations. I mean, just to give a few recent examples, there was an animal at a captive bred wildlife permit holder who was injured and died because of improper handling. There was another facility where 2 animals' bodies were found desiccated and decomposing in with dozens of other cage mates, so they'd been there for some time. These animals can suffer crippling and even life-threatening injuries, and this is all happening on the USDA's watch and in some ways facilitated by Fish and Wildlife Service. So I think there's a really big opportunity there.
Thanks. The advantage of going last is a lot of good stuff has already been said. There's not necessarily that much for me to say. Let me start, however, before I say anything substantive, by just a little disclaimer. I'm here in my private capacity today. I am not representing the Solicitor's Office or the Department of Interior or Fish and Wildlife Service. These are my own comments. I would echo a lot of what Eric said about 7A1, and I can't personally take credit for the memo, although I will point out that one of my ex-staff and my boss were the people who signed it, so it was fun to work on. But one point I want to get back to that Mary also mentioned that someone earlier talked about is if private litigation is not a good way to get at 7A1, and it is mostly an internal matter for the federal government to figure out how to implement it in a way that's consistent with the act that actually achieves conservation. You know, what are the mechanisms within the federal family to do that? And an executive order is an interesting idea. I mean, I haven't talked with anybody about this, but I think last night at dinner maybe we were talking about a parallel executive order that I did work on 20-odd years ago, which is EO 13186 involving migratory birds, right? And that was created in the time in which Department of Justice was arguing the MBTA didn't apply to federal agencies, and therefore the executive branch had to step up and say, how are we going to comply with our treaty commitments under the Migratory Bird Treaty Act if the implementing statute doesn't technically apply its prohibitions to federal agencies. And so working with CEQ and a bunch of other federal agencies, we put together an executive order that basically said, you know, here's how federal agencies should handle their obligations under those treaties that underlie the Migratory Bird Treaty Act. And it sort of set a 2-tier system. One is the executive order itself, and then it required all the agencies who have actions that affect migratory birds to enter into MOUs with the Fish and Wildlife Service, to provide some step-down detail about, okay, if you're talking about national forests, what should the national forest do in terms of migratory birds, et cetera. There's some problems with this analogy in terms of how well it's actually worked in the migratory bird context, but it seems to me that's the sort of thing that we need to be talking about if we want to figure out how we can help NIMS and Fish and Wildlife Service work more cooperatively and more effectively with the federal agencies who have all these authorities that they could be applying more aggressively and more efficiently and more effectively to species conservation. One other thing I'll add about that is that 7A1, the case law that's in this memo in particular, talks about the fact that 7A1 does not create authority in federal agencies. They have to have that existing authority, but the fact that their mission may not be focused on endangered species conservation, if they have that authority, that's something they should be looking at under 7A1. So the fact that 7A1 doesn't give them new authority doesn't necessarily provide a big limitation on what federal agencies can do. So I hope going forward, whether it's in the short term or the medium or long term, that we can take 7A1 and make it more effective with the help of CEQ, with the help of the President's office, with the help of the other agencies, because I think it very much is an underutilized authority right now. And I'll stop there, because we got a lot more questions to deal with.
Eric, it seemed like you wanted to say something in response to Ben just now.
Yeah, I mean, I think it's a great point. And one thing the memo refers to is trying to convince agencies why this is in their interests to take this approach. And again, as an outside government person, obviously I may not be in best position to describe how to do that, but one way it seems like you could do it is convince agencies that if you have a proactive conservation program, you'll be in a much better position when you take an action that may adversely affect a species, and a 782 consultation will occur. And if you can go and say, we've already been doing these helpful things for species to bring them closer to the point of recovery, much less likely to get a jeopardy opinion. Not many of those these days in any event, but even the analysis will be much more straightforward, whether you're doing informal or formal consultation, if you could provide a backdrop that the agency has been doing things that are proactively helpful for the species that are being affected when the agency does come. And the assumption behind the authority is that the agency will be doing things that probably have an impact on the species in some way, shape, or form. So thinking about ways, especially, maybe this is pie in the sky, but even with the upcoming administration, ways of persuading agencies and government officials that being more proactive under 71 could actually be useful for your overall approach to the act, may be a way that, because we like agencies to do things just because they do the right thing, and some certainly do, but usually it's better to also have a good incentive to do the right thing.
Yeah, and I think that was Gary's point this morning about enlightened self-interest of the federal agencies. If we can frame the discussion in that way, that certainly helps. I mean, ultimately, that will only get us so far, because there may be certain circumstances where we would like federal agencies to do things. It's not going to have some sort of immediate and obvious impact to help them out, but they should be doing it anyway, C7A1. And so we probably need a little bit of stick from an EO or something like that, or CEQ or someone with authority, in addition to the carrot of your enlightened self-interest.
So we're going to move now to the premise, which we're not going to discuss, that the Endangered Species Act is being under-enforced. And then I'm curious from each of you, if you could name sort of one answer to this, what is resulting in the under-enforcement of the statute? And let's maybe start out with Ben and Mary, and you can give a little bit of perspective from your time in government, and then move to Delcy and Eric. Mary, please.
You go ahead. No, I insist. That's right.
So I think there are a few things going on. I'll try to wrap them up quickly, but
One thing.
well, that's impossible. So, so when you think about enforcement, I think what's going on here is, the ESA is going to be most easily enforced by the government if, on the civil side. They're, on the crim side, it's a misdemeanor, it's typically gonna be viewed in the context of the Lacey Act. And at Interior, at least, you've got this Office of Law Enforcement, which has, primarily the view that they are there to do criminal cases, criminal investigations. And I have tried in vain for 4 years to identify a single person at Fish and Wildlife Service or in the solicitor's office who is tasked with civil enforcement. I challenge my Fish and Wildlife Service Interior folks to prove me wrong, but I do not think this person exists. And I think it's really hard, at least on the government side, it's really hard to move the enforcement needle if no one is in charge. You talk to one person, they're like, oh, it's OLE. OLE's like, no, go to the solicitor's office. There's no one who's tasked with moving civil enforcement. So I'm gonna say that that is my one response.
Yeah. And that's a very fair point. I don't have a good rejoinder to that. I will say that when we talk about under-enforcement, there's a question of, what does that mean? One thing occurred to me from the conversation before lunch. We were talking a little bit sort of the shadow things that happen outside of the obvious context of Section 7 and Section 10. I think that notwithstanding maybe some concerns about transparency, one of the goals of the Fish and Wildlife Service and people we interact with is to try to avoid take in the first instance. And so I would view a lot of those efforts as success stories because we have avoided having to authorize take by working with people to reduce or eliminate take. The other thing I'll say, just to respond a little bit to Mary, is it's absolutely right that there's definitely an issue about priorities in the Office of Law Enforcement at Fish and Wildlife Service. I mean, they do view criminal work and in particular like international wildlife crime, trafficking issues as being among their highest priorities, as well as enforcing against take and commercialization of take. Those are the things that really those law enforcement agents have cut their teeth on and they view as the things that they've been asked to do. And so there may need to be a culture change to get to the place where you're talking about getting.
Delcy, maybe we can start with you and then move to Eric.
Yeah, so I'm going to stick with the focus on captive wildlife, not suggesting this is the only issue, but I do think it's an important and often overlooked piece of the puzzle. And so I would say a lack of coordination between the USDA and the U.S. Fish and Wildlife Service. So as we've said, the USDA is observing Endangered Species Act violations constantly, but there is no mechanism to communicate those to the Fish and Wildlife Service. There is a recent MOU between the Department of Justice and the USDA. It's promising. It remains to be seen how it's going to play out, but Fish and Wildlife Service isn't a party to that. So while the MOU prioritizes, among other things, situations in which there are both Animal Welfare Act and Endangered Species Act cases, there's no coordination with Fish and Wildlife. And I think this overlaps with Mary's point that there's not a point person to even oversee such coordination. And somewhat related to that, I think, going back to the captive bred wildlife permits, there is inspection authority that comes along with those. And according to FOIA responses I've received, that authority is never exercised. And even when there are documented violations by a captive bred wildlife permit holder, there's never revocation of the permit. So I think those are some pieces.
So I think there's a reason why Section 9 has been under-enforced in the wildlife context that actually applies both to NGO enforcement and to government enforcement, although in a obviously different kind of practical context. And that is, Section 9 litigation is difficult, it's resource intensive, and personnel intensive. And that is true for a number of reasons. Unlike an Administrative Procedure Act claim, administrative record claim, these cases involve intensive discovery most of the time. I mean, there are some egregious violations in the wildlife context, but most of the time, establishing that a take is likely to occur in the future, reasonably certain, which is basically the standard that's been established in the case law, is a difficult proposition. It requires expert testimony. You frequently, especially if you're going up against private companies, excellent attorneys, some of whom are here in this room, and they know how to get their own experts, and these become battles of expert testimony. And there's an important case called Sweet Home that I'm sure most everyone is familiar with. Great in one sense, it upheld a definition of harm within the take definition that encompasses adverse habitat modification, but it also requires to establish that actual death or injury will occur as a result of various interference with behavioral requirements. So it's difficult, it's expensive, and it takes a long-term commitment to do. In the private enforcement context, there is also the risk of countersuit. Some of us know about that quite well, and other sorts of risks that you don't really have when you're litigating against governmental entities. So I think that actually probably explains to some degree why Professor Edelman's numbers, I think there may be a few more out-of-court settlements that may not have made it into the statistics, but it certainly reflects the difficulty of private enforcement. And in government enforcement, I think that's part of the problem as well. It just requires a real commitment of resources and personnel to do it. And taking, I think, the notion that a lot of this is worked out on the sidelines, yeah, I think I accept it, at least to agree that that is the case. I do believe that the Fish and Wildlife Service could do more, at least in rattling the saber some. And by that I mean, if you look at some of the letters that go back and forth between the service employees, again, who are doing extraordinary work against difficult circumstances, there's almost this sort of pleading element to it. It would be really good if you would do these things for these listed species. By the way, the Section 9 may come into play. We're not telling you it will. There's this thing called an incidental take permit. That's voluntary, that's not mandatory. I think the tone, and again, I'm just giving this my perspective from the outside, having read a lot of these communications, the tone, I think, could be changed. Not to, you don't want to have communication back and forth, but to be much more emphatic about this is a legal obligation. And of course, if it has to be backed up to some degree by a threat of some kind of enforcement action, that would all make it all the more likely to yield a conservation benefit, even if the ultimate deal is worked out without going through the formal process. So I think there are some changes that could be made in that way. But ultimately, I think, even if the federal government, and I don't expect this to happen, obviously, in the immediate future, but looking down the road, we've learned that one lawsuit in an industry that focuses on a particularly egregious actor and sends a message can really ripple out throughout the industry. So with the right target, you can actually make it clear, yes, we're serious about this, and you can leverage resources in a pretty cost-efficient way by making clear that you do actually have at least some meaningful threat of enforcement to couple with the other ways, once again, the carrot and stick approach of trying to work things out in a way that yields good benefits, but at least having at least some threat that enforcement action would be taken, seems to be critically important for that to occur.
We have another minute.
We do,
Yeah.
and I think Mary and Ben, you both have some thoughts in response to what Eric just said.
Well, I was just thinking as you were talking, Eric, I mean, I absolutely agree that it's important to have credibility in terms of taking enforcement action, and taking enforcement in appropriate actions is crucial to having that leverage and that credibility. An example of that, not in the ESA context necessarily, though, is in the wind context with eagles. DOJ brought a couple of big wind cases, Eleanor Colburn and folks like that, and I think that got people's attention in a way that maybe we didn't have before. Mm-hmm. So you could extrapolate that to the ESA context and other contexts as well.
And to add to what you're saying, Eric, these cases enforcement cases are resource intensive. And, I think Fish and Wildlife and NIMS, they're not alone in this. There is a role, obviously, for the Department of Justice to play. And part of the problem that we have, part of the problem I think that we have is that In my old division, the Environment and Natural Resources Division, usually you will have a section that is charged with the enforcement side of certain statutes, and you have a separate section that's charged with the defensive side, defending the agencies and those actions. And in, my old section, the Wildlife and Marine Resources section, it's one section, so it's a primarily defensive section. And when there's the bandwidth and the resources, then you can also do enforcement cases, which I think leads to very few enforcement cases. I think probably if we were gonna get serious about enforcement, whether it's in the wildlife or the captive context, and whether it's the Endangered Species Act or other similar statutes or related statutes, I think we would need to be talking about another structure in the Environment and Natural Resources Division that allows for a team, whether it's its own section or a subsection, that is actually dedicated to this work.
Thanks, Mary. That's a really good organic tie-in to our next question that sticks with this kind of concept of civil judicial enforcement of the Endangered Species Act, but also against the framework of where we're at right now after the last Supreme Court term and the implications of SEC versus JARC. So I would be curious if we can start maybe with Delcy and Eric on this, about what do you think is the role that citizen suits play, and what are some of the benefits, drawbacks, and limitations of citizen suits in civil judicial enforcement of the Endangered Species Act? Eric, I know you talked a little bit about the kind of resource constraints that even sophisticated large national nonprofits have, but what are some of the other factors that come into play when we're talking about citizen suits and how we can have more enforcement of the act?
So I alluded to some of that, the resource constraints, the commitments that it takes, the increased risks. I would say those risks are somewhat mitigated when you're dealing with certain kinds of Section 9 enforcement. And just to bring this into the discussion, there's what's called the Strahan v. Cox line of cases that people may be familiar with, which is basically where you sue a governmental entity. Generally speaking, a state agency, because if it's a federal agency involved, there's other ways of dealing with that. But there have been a fair number of cases. Max Strahan is actually a local hero or villain, depending upon how you want to look at him, who's done work on the right whale. A lot of people may be familiar with Max. But anyway, he established an important precedent, which you can sue an agency which is authorizing private conduct that in turn results in a take. And so that is a certain kind of litigation that should be kept in mind for that I think there has been more of and likely could be more of going down the road. But I do think part of it in the private context, just to be very practical about this, is that a lot of lawyers, and we're in an esteemed law school, learn a lot about legal principles and that sort of thing and how to write briefs, but don't necessarily learn as much about what it takes to do a Section 9 case. And we have people who have done them, and it's basically a different set of skills. Doing discovery and doing trial work and cross-examining witnesses is not what a lot of the lawyers who grow up in the environmental world know how to do. So part of it, and I do know that Tim's shop has a Section 9 case going on right now. And so basically training more people to do this kind of work, which is sort of par for the course in other areas, Clean Water Act enforcement, et cetera. But it's really critically important for the NGO community, I think, to establish more expertise in that area. So I think that's certainly, a significant, factor to take into consideration along with some of the other things we've talked about.
Yeah, and just to add to that, I think, the citizen supervision is so important, so valuable, but it's meant to be a supplement to government enforcement. It is not meant to take the place of government enforcement, and bringing these cases is hard, and there are a lot of challenges. So in addition to what Eric has mentioned, standing is a challenge. I know the first panel was mentioned that standing's not really an issue in these cases. At least in the captive wildlife context, it is an issue, and you can spend years litigating standing, and even if you're successful in the end, which is often the case, those are years during which the ESA violations are continuing. Then there are costs. These are expensive cases to bring that can be quite extensive discovery that's often protracted and contentious. So I could regale you with stories of discovery shenanigans, but I'll just generally say defendants ignore court orders, animals go missing, spoliation happens, and all of that makes the litigation more expensive, more time-consuming with motions practice, poses evidentiary challenges, and again, prolongs the ESA violations. And then ultimately, the cases typically often come down to a battle of the experts, and experts often cost money, often can be expensive. So just to give you a sense of what these costs can be, a court awarded PETA more than $1 million in one of its ESA cases for fees and costs. In another, it was more than $750,000. And that shows you how costly it can be, and it's the likelihood of actually recovering that money is slim to none. And sometimes courts refuse to give the fee awards, even when you prevail. There can also be collateral expenses. So in the captive context, there are expenses associated with placement. The number of placement at reputable sanctuaries is far less than the numbers of animals in need of help, endangered animals in need of help in captivity. And so oftentimes the NGOs bringing these cases will also have to spend money to build out more enclosures for animals, and that's costly. There are transportation costs as well. And then sometimes the defendants will come after you for attorney's fees if you're not successful. We're seeing that increasingly. As Eric mentioned, there can be retaliation, counterclaims. So numerous ESA defendants have brought RICO lawsuits, not just against plaintiffs, but against plaintiffs' counsel, including yours truly. And frivolous RICO suits can be defeated, but they, again, take time, take resources. And then I think there's some challenges that are particular to the captive context. So one is split listings. So a split listing is when the listing of a species distinguishes between captive members of a species and their wild counterparts and treats the two differently. And the Fish and Wildlife Service has recognized that that is illegal. But numerous split listings are still on the books. So there are 11 primate species who are split listed, and the Canada lynx is split listed. So sometimes you first have to litigate over getting the animal listed. So that was the case with Lolita, Tokite, Scali, the southern resident killer whale at the Miami Seaquarium. Sometimes you have defendants argue that the animals they hold are not members of a protected species. So the Cherokee Bear Zoo, when they were sued for takes of grizzly bears, despite having referred to their grizzly bears for many, many years, suddenly insisted they were not grizzly bears. And then the USDA's failure to protect these animals under the Animal Welfare Act can pose hurdles because you have a facility that, despite horrible treatment of these animals, despite trafficking these animals, holds a USDA license, often has for many years, sometimes for decades. The USDA has taken no action against them. And so a court can be reluctant to step in that kind of situation. And then I think all of this is compounded by the regulatory definitions that pertain to take. So the take prohibition is broad, and it's defined to include harm, harass, wound, kill. There's a regulatory definition of harass that provides for differential treatment of captive animals. And so it provides that generally accepted animal husbandry practices that meet or exceed the Animal Welfare Act standards and are not likely to result in injury to the wildlife don't constitute harassment. And courts have really struggled to apply this carve-out. Some have ignored altogether the generally accepted language. Some have deferred to the USDA as to whether or not there's Animal Welfare Act violations rather than doing their own determination. Some ignore the not likely to result in injury language. And appellate courts have called the trial courts to task on some of these things, but the courts continue to struggle. And the regulatory definition of harm, which Eric mentioned, doesn't distinguish between captive animals and their wild counterparts, but at least one court, the 11th Circuit, has interpolated a distinction. So in the case involving Lolita at the Miami Seaquarium, the 11th Circuit said, even though the ESA prohibits harm, period, full stop, the 11th Circuit said it has to be serious harm. And then despite noting 13 distinct alleged injuries to Lolita, including mental anguish from solitary confinement for years, needing her teeth to be routinely drilled, needing twice daily eye treatment, etc., refused to allow it to go to trial as to whether that new standard, serious harm, was met. So those are some of the challenges we encounter.
Mary, go ahead.
So I'm a big picture person, and when I hear what Delcy has to say, I think 7A1. I think, what if Fish and Wildlife Service met with USDA and walked through, I brought on behalf with, Fish and Wildlife's blessing, with USDA's blessing, several cases that included ESA take claims, but those types of harm are happening all the time. People love to come in contact with endangered and threatened species. I mean, I feel like the ringtail lemur is just like the perfect example. It's like the new tiger cub, right? And if we had Fish and Wildlife Service working with USDA to kind of walk through what they're blessing in terms of when they're inspecting the licensed facilities, I think that so many of the things that people are litigating about could be addressed with just hey, this is take, stop approving this. And I think that USDA would probably be receptive to that. It's just the agencies aren't talking. They're not communicating enough. They're not coordinating enough. And, rather than trying to play whack-a-mole here or try to sue every facility that is engaging in the take of endangered species, threatened species, this is where, behind the scenes, agency cooperation and coordination, I think, could play a huge role.
Well, Mary and Ben, I'm curious, what role can the services play in coordination with other agencies to institutionalize this civil judicial enforcement of the statute? What does that look like on a practical, on-the-ground perspective to the both of you?
Yeah, I mean, I guess I don't have a ton to add on that. I mean, we've talked about the need for coordination, both within the Solicitor's Office, Office of Law Enforcement, DOJ, and then with other agencies like USDA. I mean, that all makes a lot of sense to me. I know we really haven't talked about I'm not even going to try to pronounce the case, Jarchese, whatever.
I looked it up and it's Jarchese.
Jarchese.
Jark like shark, C like Tennessee.
Nice, the Jarchese case, which I think came down just as I was signing my retirement papers. So I hadn't thought about it very much, and in fact, I only sort of read a summary of it probably yesterday. But for those of you who don't know, I mean, the Supreme Court essentially said that that agencies can't use sort of administrative ALJ type enforcement proceedings except in limited circumstances. If it's a legal remedy as opposed to an equitable remedy, that's one of the issues. And then whether or not there's an exception that applies. But it basically sort of, it was in the SEC context, right? Hamstrung the SEC ALJ administrative process. And there was some concern about what effect that would have on other agencies that do administrative enforcement. I haven't talked with folks in the solicitor's office or in the service or DOJ about that in particular. But I mean, it seems to me there's an applicability question about are we talking about legal versus equitable relief, and does the exception for the public right exception apply? But if it does. If those things do apply, then if the Jarchese line of cases does apply, then yeah, we can't do administrative ALJ type enforcement, which again we tend not to do. So that's going to require civil judicial enforcement for all the reasons we talked about before. Coordination is going to be important. But anyway, that's what I have.
Mary, do you have anything more on how we institutionalize this other than creating a new section at the Justice Department?
And in a position at Fish and Wildlife or the
Solicitor's
Solicitor's
Office, right? Yeah.
Is tasked with civil enforcement.
Get on that.
I'm looking at a few of you here. But yeah, I mean, I think that beyond that, serious training. You have to train up your own staff. You have to train up I think, again, whether it's OLE or there's some separate, I think it's really tough sometimes, although maybe there's some folks in the audience who would counter this, but I think it's really hard to get agents to kind of be thinking in civil mode. It's really hard to convince them that it's worthwhile. Yep. And I think that there is so much that you can do with civil enforcement, sometimes way faster, way more effective than going the crim route, even though I think that there's definitely a role in it, and criminal enforcement is important. But I think there has to be some education about the importance and the benefits of civil enforcement. There needs to be training of other agencies regarding what constitutes take and what they should be authorizing. I actually had, in one of my cases, I had an attorney say, my client had no idea, USDA knows this is going on, everybody's doing X, Y, and Z, and we had no idea that the federal government or Fish and Wildlife or whoever's gonna take the position that this violates the Endangered Species Act. I mean, again, this is an education issue, a coordination issue, but.
And a culture issue, as we talked about before at the Office of Law Enforcement, right?
Yeah.
Can I speak briefly to jargosy? So just a little bit more background for those in the room who aren't familiar with it. This was a 7th Amendment case, and so the Supreme Court held that when the SEC is getting civil penalties, fines, from someone, they need to give them the right to a jury trial. And the reason for that decision was that the SEC's anti-fraud provisions replicate common law fraud. So basically, by doing an administrative proceeding, the idea is you're doing an end run around a right to a jury trial that they would normally have. And so I think we should be careful about being too quick to assume that the breadth of jargosy's application. Obviously, it's ultimately going to be up to the government about how broadly they want to interpret it, not up to me. But I think it's worth flagging that the cause of action in the ESA context has no common law analog. That's why enactment of the ESA was so monumental. So it's quite different. In the words of Jargosy, the ESA brings no common law soil with it. And Jargosy noted that under the public rights exception that was mentioned, you can have some enforcement administratively. And in one case, the court upheld OSH Act, Occupational Safety and Health Enforcement, and noted that that was a self-consciously novel statute. I think you could say the same about the ESA. And even if you disagree with this, I think that at the bare minimum, Jargosy still allows for at least permit revocation to happen, and that's an authority that Fish and Wildlife could exercise.
And Delcy, when you talk about permanent revocation, you're talking about a license.
A Section 10 permit. So if someone's got a take permit of any kind or a permit to engage in otherwise prohibited activity.
Or one of those captive breeding.
Yeah, which is a captive bred wildlife permit. It's a type of Section 10 permit, yeah.
So I am interested, sticking with this theme of enforcement of the statute, how is it, structurally speaking, that we're getting facts to the right people for enforcement, right? Acknowledging the resource constraints with branches of the service like OLE, acknowledging the resource constraints when it comes to NGOs being able to gather the facts to bring these types of cases. And so maybe let's start with Eric and Delcy. How do facts for enforcement cases get to NGOs for citizen suits? And what are some ways to make that process easier, more efficient, more robust? Or are there sort of inherent shortcomings like we were discussing earlier with the role of citizen suits in enforcement of the statute?
Want to start with it?
Sure. So again, focusing on the captive, noticing a theme. So the USDA Animal Welfare Act inspection reports are actually really important in this context. So the USDA's enforcement of the Animal Welfare Act is abysmal, and its Inspector General has been saying that for decades. but it is documenting violations. As Mary said, you can go online and look at these inspection reports and see documented violations that are also ESA violations. And so those are a really important resource. And I think this underscores with the incoming administration the importance of transparency. So 2 weeks into the last Trump presidency, thousands of Animal Welfare Act records were taken offline, including the inspection reports. Records that the agency for years had acknowledged it was required to post under EFOIA's affirmative disclosure mandates. And so we need to be fighting to ensure continued access to that sort of information. For animals who are on exhibit, observations from the public can be really important. And animal protection groups hear all the time from people who go out to these facilities and are distraught by what they observe. But that only helps the animals who are on display. So animals who are held by breeders, dealers, experimenters, and there are permits out there for invasive experimentation on endangered animals. There's no eyes on those, particularly when no inspection's happening by Fish and Wildlife. So in those situations, you have to rely on whistleblowers or undercover investigators, and that's complicated, and there's retaliation in that context. So that's captive context.
So in the wildlife context, I think there's really no substitute for people who are on the ground observing what's actually going on. As luck would have it, an organization like the Center has people all over the place who have good contacts with grassroots activists, and they frequently are the ones who will hear about things first and will let you know about things to look into. So that really is, I think, vitally important, not to assume that all the information resides with people who actually happen to be the ones ultimately pursuing a case. People sitting in Washington, D.C. or New York City or whatever it might be, but really appreciating that the people who are out there in the field are the ones who frequently know. And these can be, citizen activists, these could be scientists. And I would say that relationships with the scientific community is particularly critical in the context of wildlife. They will frequently know about things that may be impacting species they study. We talked about some of the real high-profile species. People will know, generally speaking, about grizzly bears and wolves, but of some of these much more obscure species, there's literally sometimes only 1 or 2 or 3 people in the world who know a lot about those particular species. We probably all have our favorites, here. I am actually doing a case on the American burying beetle right now. And so basically being in contact with those people and making sure you're having access. I mean, an interesting discussion could be had, I'm not suggesting right now, about the extent to which the conservation scientific community has evolved over the years from one that was really taking a more dispassionate approach to one that's like, well, the things we're studying are in the process of going extinct. So we can't just sit back and be objective observers while we watch the natural world disappear. We actually have to play a more proactive role, and one can debate, whether that's really a proper scientific role, but maintaining those relationships with the scientific community is critically important. And just to touch on what Elsie was referring to, I think also applies in the wildlife context. Open records laws are really critical. Not only the federal law, and as people may know, the ability to use the federal FOIA has become much more problematic over the last number of years. We've had a really, from the standpoint of those trying to get access to records, a seriously problematic decision case called Sierra Club, which specifically arose in the context of Endangered Species Act Section 7, and made it very difficult to get any Section 7 document prior to a final biological opinion. And then in the Section 4 context, we had a case called Argus Leader, which made it much more difficult to get access to documents generated by private parties. So that's become more difficult, but it's still worth pursuing. And then the state records open government laws can sometimes be far more useful. One of the big Section 9 cases, I don't know if it made it into the database, probably not given the numbers, but that was wrapped up by some great lawyers at the center suing over timber projects in Oregon. They used documents generated by the Oregon Forestry, whatever the agency is, reflecting what the timber cuts was and the impact that was having on coho salmon. And their own documents became a critical part of the case and ultimately led to a really good settlement where they've agreed to adopt some pretty major mitigation measures for trying to prevent the worst impacts on coho. So using open government laws, I think, effectively, and learning how to do that is also a really important piece of making this effective.
Mary and Ben, can you talk a little bit about how, facts get to the services, from program staff, OLE, and other federal agencies?
Yeah, I can speak at least a little bit to that. All those are sources of information. The program experts, as part of their monitoring of listed species, will come across fact patterns that they'll refer to the Office of Law Enforcement for consideration for investigation. OLE has its own fairly intense ways of doing investigations and of undercover operations that will come up with facts that they'll take to the Department of Justice. Other agencies, I think that's probably an area for better relationships. I don't know how often we get the Forest Service coming to Fish and Wildlife, Office of Law Enforcement, saying, "Hey, here's something that's going on that we found out about, and that it might be worth an investigation." I don't recall hearing about a lot of information coming in through that mechanism, but Mary?
Yeah, but that also, it seems to be at a regional base. I find I'm still
might wanna move the
confounded.
mic over.
Oh, yeah. I'm
Yeah.
still confounded by the setup of OLE, how they function, but, I think, probably the same ways that we've been discussing. I certainly relied on USDA inspection reports on the captive front. Sometimes we worked with OLE, but, I think one tool that could be really useful if there was an interest in this is the testing. So, we've had cases, I feel like bears are the most common example. It's like, I have this grizzly bear until it's a Kodiak or whatever. It's like always, it's never, somehow all of the bears in the lower 48, like none of them are from the listed.
Wolves too. Wolves
Yeah.
is another one where we see that.
And so.
It's just a coy dog, right? Yeah.
Yeah, or they're all half wolf,
Dog,
half
yeah,
dog
yeah.
hybrids. But I think what would be great, so it's not how I'm getting information, what would be great is if, there's Fish and Wildlife has, my understanding is a lab that can test species. It can be very difficult to get access or to prioritize the thing that you want tested because there's such a backlog, and I think that's a resource issue. But that could help in some of these, with particular types of species, could be a source of information that I think is not being used enough. But
Yeah, the Ashland Lab is a world-class facility, but I'm sure they have a big workload.
So I'd like to end with moving to habitat conservation plans and specifically how HCPs, we've heard a little bit from panelists in the morning about they're resource intensive, they take a long time. How do we make HCPs an appealing option to replace or mitigate the need for Section 9 enforcement? Eric, I know you have some thoughts.
Well, I don't think it would ever replace the need, because again, I think I see them working in tandem, where there's got to be some realistic threat of Section 9 enforcement to have people sufficiently motivated to go through the Section 10 permitting process. But along with that, the process has to be made a reasonable, efficient, and reasonably certain process. Not to say it has to be a certain outcome, because any agency decision-making has to, of course, assume that there could be multiple outcomes. But, I've been involved in litigation, including Section 9 litigation, with attorneys representing companies who have basically said, yeah, I would go get an ITP if it wasn't like unbelievably torturous and expensive and complicated to go through that process. And it does seem to me that it is one of those areas where there should be some consensus that making that process, and I don't blame the services for this. It's a difficult process. There was public comment. You have to do NEPA on HCPs, ITPs. They also do intra-agency Section 7 consultation, which could bring into play other species that are not necessarily even the target species for the HCP. So there's a lot of pieces, and the services just have not had the personnel, in my view, to make it work efficiently. So this is one area where you would think, including in the administration we're going to have, there would be some ability to go and say, we all would benefit by making this process work better. And making it a process that can, just like has been done, and we could debate about how much should have been done with the NEPA reforms and the page limits and the time limits. But the idea of basically saying this is going to be a process, we're going to bring the best available science, we're going to bring the best thinking, but we're going to do it efficiently, we're going to give you an answer quickly, one way or the other, we're going to tell you what you need to do to get your take authorization. That's a place where there should be consensus, it seems to me. So anyway, I'm sure it's a lot more complicated than that. But I think it's one area to really think about, especially in a conference like this one, when you have people different perspectives, but all of whose interests would be served by making that process work effectively, efficiently, and reasonably quickly.
Yeah, and the devil's in the details. I mean, I'm sure if we had another half an hour, we could probably drag Gary up onto the stage and he could talk about why it is as hard as it is to do that. But that's a criticism we've heard for a long time. There have been some recent efforts. The Section 10 reg revisions from last year were one effort to do that. There's also the question of the relationship between Section 7 and Section 10. And right now, as related to the apparent difficulty in getting a Section 10 permit is this desperate desire to fit everything into a Section 7 context, because somehow that's way easier and faster. And that has created its own set of tensions. So I mean, one way to get at this problem is to get it from both directions, right? To figure out ways to streamline and make Section 10 more appealing for the applicants, and also to do what we can to make Section 7 more equivalent to Section 10, not in terms of it being painful, but in terms of getting good conservation out of it. And the ESA regs from a couple of years ago, which tried to provide for the potential for more aggressive mitigation under Section 7, which has been viewed as something that Section 10 is stronger on, is an effort to do that, I think.
Can I just make one comment about that? I think that problem is going to become of using Section 7 instead of Section 10, and people debate the merits and why people do that. But with the Sackett decision, which cut backs, I mean, one of the major ways that people were going through the Section 7 process or using that was basically the wetlands hook. And now that we're going to have far fewer wetlands covered by the Clean Water Act and require 404 permits, even the ability to do that. So in a way, that actually may increase the motivation to look at ways of making the Section 10 process, because that Section 7, however you want to put it, off-ramp alternative may not be as readily available to people who are looking at it as a way of getting take authorization.
No, that's a great point. I completely agree.
Mary, I know you have some experience litigating HCPs in court. You don't want to talk about it?
I'm not sure where you're going with this, but.
Did you want to talk a little bit about how it is after an HCP has been created and it's implemented, and then it sort of breaks down and it gets to court?
No, I actually worked in this sort of unusual context of prairie dogs where no one wants to do anything for prairie dogs. So in that moment, Fish and Wildlife Service decided to develop a general conservation, GCP, which I don't even know if these things still exist, but it was a way for them to draft the plan instead of having the counties and the different entities come to them. And
then let people sign up for it rather, yeah.
Yes, but they're the ones who did the heavy lifting there. So I'm not sure, I'm out of the loop on that front of whether or not that is still something that the service is doing.
Gina says yes.
All right, Gina. Yeah, I can't really say whether that process works or you get enough people on board to make it work. But.
We have a little bit of time for audience questions. If people have questions for the panelists, maybe let's just line up the microphones. Easiest.
Hi, from Southern California. Okay. So I was recently, well, actually for 7 years, involved in litigation against the Army Corps of Engineers over a dam in Southern California on the plaintiff side with Center for Biological Diversity and Endangered Habitats League. And during the settlement discussions, an attorney representing the Army Corps of Engineers from DOJ said that the conservation measures within a biological opinion are suggestions and they are not requirements of a project. And I had never heard that said before. So A, I want to confirm, is that true? And additionally, it gets to a bigger point, which was kind of a hole in this conversation in that I also used to work for U.S. Fish and Wildlife Service, by the way. So when a biologist writes their biological opinion, they're doing the analysis of how do you offset the take and the modification of habitat that is being authorized through that biological opinion. And one challenge that I see is there's very little bandwidth, if any, for anyone to go back and to look, are these conservation measures that are in biological opinions that are intentional in their conservation benefits to the species, are they being required, or are we following up on them? Because if not, then are we actually just seeing death by a million cuts authorized through these BOs, that over time, that conservation benefit is lost to those species that was intended by whoever was, writing that biological opinion. So if you could answer my question about whether BOs are actually just suggestions or not, and then, how could the service do better in terms of the conservation follow-up for biological opinions that are issued to projects through Section 7? Thanks.
Well, I can start, and I encourage anyone who has more Section 7 expertise than me to fill in if I get anything wrong or add to it. But so a biological opinion is not binding on the agency in a certain sense, right? Because the agency makes the decision. Fish and Wildlife Service is providing a consultation in the form of a biological opinion. Where the rubber meets the road is the incidental take statement, right? So if that comes out of the BIOP process, a biological opinion process. So if an agency wants to have the coverage provided by the incidental take statement, they have to comply with the terms and conditions and associated with that, which come out in essence of the biological opinion. So the biological opinion itself is not binding, but there is the safe harbor of the incidental take statement that requires, in order for it to apply, that the agency meet those terms and conditions that are involved. Gary, was that close enough?
Close.
Close, okay, please. This is a danger of having a Section 4 lawyer talk about Section 7.
So first, Heather, conservation recommendations are in fact recommendations. But
Conservation measures within the biological opinion.
we need to be careful about the language there, conservation recommendations. So the heart of a Section 7 consultation is to determine whether an action is likely to jeopardize the continued existence of a species. That's the heart of that consultation is about. If not, if it doesn't jeopardize or adversely modify critical habitat, and there is still residual harm, an incidental take statement is issued to exempt that take from the prohibition under the Act. But you only get that exemption if you comply with the reasonable prudent measures and terms and conditions, and those are not discretionary if you want to have the exemption from Section 9 prohibition. Right. And then we're in the little survey about bold action. I would just encourage you to look at the revisions to our Section 7 regulations that were issued in 2024, in which we clarified our authority to actually issue and require RPMs that serve to offset the residual impact, not just minimize, but to offset. Think of compensatory mitigation. So it no longer death by 1,000 cuts, but rather no net harm. Whether that holds, we'll see. It's already been challenged, but those are the sorts of things that we are purposely trying to improve the conservation effectiveness of Section Section 7.
Well, while you're up there, Gary, can you just talk about what is the mechanism that you make sure those things are done after BIOP is issued?
First off, the biological opinion is issued to a federal action agency, and normally they're made conditions of a federal authorization or permit. And it's those agencies that are primarily responsible. Service could play a role, but we're not the cop. We're not the police force for the entire federal government.
If they're violated, who's going to regulate the federal government action agency?
They're violated,
Citizens.
that's where certainly there has been citizen suit litigation brought in the past.
So I think that's the problem that we're getting at, or that folks are getting at here, is that when the other federal agency is the one not complying with RPMs, it's like, whose job is it to ensure that there is compliance? Is that the NGOs, the third parties, to get the information that the RPMs aren't being followed and to enforce? Or is it, like, is there a role for Fish and Wildlife or NIMPS, or is there a role for DOJ, or is there, like, what is, who's going to be ensuring compliance here?
Yeah, no, and I think part of the answer is that it can't be just, it's up to NGOs to police those things. I mean, the Fish and Wildlife Service is, or NIMS for their species, I mean, their goal is to conserve the species so we can get them delisted, right? And if the Section 7 consultation process isn't working and people are not complying with the suggestions that got them to a no jeopardy call, then the Fish and Wildlife Service needs to have some mechanism for monitoring that and then calling the other agency to the carpet. And you know, there is in the regs reinitiation triggers. So one of some of those reinitiation triggers would relate to the failure, but getting from like A to B, from knowing that that's happening, that the reinitiation trigger has been activated, and therefore getting the agency to decide that it is going to reinitiate consultation. Again, it's easier in the context if they have concern about take authorization and whether or not they have a valid incidental take statement that's going to apply to their actions anymore. But yeah, it's a challenge.
Lawson?
Even if they're reinitiated consultation, though, and then there's no incidental take statement covering that reinitiation yet.
So yeah, if an incidental take statement is no longer applicable because they're not meeting the terms and conditions of reasonable prudent measures, they reinitiate consultation, they're hanging out there until they complete that consultation and get a new incidental take statement that applies to their actions. I mean, that's a vulnerability that they have.
And if you have an ITS, but you're not complying with the terms and conditions, you can be subject to Section 9 liability. So I handled a case for the Army Corps and NIMFs when I was with DOJ, where there was challenge to a BIOP, Section 7, I had 2 claims against both agencies, and then there was a Section 9 claim against the Corps saying you're not complying with or you don't have a valid incidental take statement. So that can be part of it.
Yeah, and it's not just take, to be clear. If the measures that were relied upon were the basis for the jeopardy opinion, I think this is what Gary was also alluding to, the agency's potentially liable for not just the take, but for a more fundamental 782 violation if the basis for the no jeopardy opinion was compliance with what was committed to in the biological opinion. So there are a lot of ways in which the agency is theoretically subject to liability. In the real world, it becomes a lot more complicated, depending upon what the fact pattern is. And that's why having some mechanism where the service is actually playing more of a proactive role of policing these things would be extraordinarily helpful in the real world.
The other piece of it is that I've seen this a lot with the Forest Service. Conservation measures will be incorporated into the action itself, and then the BIOP is based on that. And so those are also, at least in theory, binding, but again, the enforcement or mechanism or whatever is an open question. I did have a question myself, yeah, which is particularly in terms of captive wildlife, what do you see as the role of accreditation? So if a facility has an accreditation from AZA or ZAA, should that be something where the agencies work more with those trade groups, or is that valuable?
Well, first I'll say there's a vast distinction between AZA and ZAA, and AZA has much more rigorous standards. I think where it can come into play, but it's been complicated, is when you look at the harass regulatory definition and the carve-out, it refers to generally accepted animal husbandry practices. And what the courts that have grappled with this have said is that accreditation standards, AZA accreditation standards specifically, are sort of a higher level. They're above generally accepted standards. And so we can't hold people to account, and essentially saying that the harass exemption is vague. It's too vague. It doesn't offer a lot of guidance. So I think AZA standards could be a really useful thing to look to what husbandry practices people should be engaging in. But I think as private standards set by private entities, we shouldn't be delegating to them in any way. I don't know if you want to add to that.
I think we're at time for our panel, so.
Can I just say something for like 10 seconds? Because it's just to let everybody know, because there was a lot of talk about 7A1. I just want everybody to know that at UC Irvine, we've been working for 2 years on an empirical study with Defenders of Wildlife on 7A1. We've been working with all the federal agencies on it. We've got a bunch of interviews, we've done workshops, et cetera. So if any of you are interested in 7A1, we've been working with the Fish and Wildlife, et cetera, on that. So please let me know, and we're happy to get you involved. So that's it.
Thank you. I just want to thank all of our panelists for having a really robust discussion about creative solutions under what has been a difficult fact pattern and what is going to be an even more difficult fact pattern. So thank you all.